All right, well, hello, good evening, everyone. Welcome to this one-day UVA virtual talk series. My name is Susan Lynch. I am the Associate Director of Lifetime Learning at the University of Virginia's Office of Engagement. Today, we are joined by two distinguished faculty, Corinne Field and Sarah Milov. Corinne Field is an Associate Professor in UVA's Department of Women, Gender, and Sexuality. Her research focuses on the intersections of age, gender, and race in U.S. history. And Sarah Milov is an associate professor in UVA's Corcoran Department of History. Sarah is an historian of 20th century US history. Her research focuses on how organized interest groups and everyday Americans influence government policy in the terms of political debate. So I want to thank both of them for being here today. Lifetime Learning received several questions in advance of this program. If those questions are not answered in the course of the presentation, we'll get to them during the Q&A. If you have a question during the event, please enter it in the chat box below. Please add your name and UVA affiliation to your question. I want to mention that we have registrants for this program from 38 different states and 6 different countries spanning the globe. So welcome to everyone. So thank you again for joining us for this Lifetime Learning program. It's my understanding that Professor Field will be starting us off. So Corey, please take it away.
Hi all. I want to thank Susan so much for those nice introductions and for organizing this event, and Sarah for teaming up to do this, and all of you in the audience for taking time out tonight to think about the history of women's suffrage. So when you think about the history of women's suffrage, a standard story may come to mind that goes something like this. It started with the Seneca Falls Convention in 1848. Women finally won the vote in 1920, but little changed because women voted just like their husbands. Basically, every aspect of this story is wrong. So first, the beginnings. The organized movement for women's political equality coalesced earlier in the 1830s through an interracial movement to end slavery. In her recent book, Vanguard, Martha Jones shows how African-American women in the North provided leadership and innovated strategies that linked women's rights to racial equality. Later generations of Black women would continue this struggle, sometimes allying with white suffragists and other women of color, and sometimes working separately within Black churches and clubs, but always viewing the vote as part of a broader struggle for justice rooted in the experiences of Black women and their claims to dignity and equality. Even for white women, equal citizenship was always about much more than the vote. So my own research looks at women's fight to be recognized as adult citizens, that is, no longer to be classed as children dependent on men. Women wanted to vote for themselves and also to determine their own course of life, to assert their independence from husbands and fathers, to pursue their own goals. The project I'm working on right now traces what happened as abolitionists and women's rights activists grew old in public in the 19th century, persisting as activists into their 50s, their 60s, even their 70s. These women, Black and white, invested a great deal of energy in fighting what we would today think of as ageism. That is the idea that older women are out of date, ugly, irrelevant. They wanted to change these attitudes towards aging because they saw that as essential to winning political power. They realized that men tended to be elected to office in their 50s or 60s, and women would need to be respected as they grew older as well. So the women's suffrage movement was long, interracial, and focused on much more than the vote. So what about the idea that women won the vote in 1920? So this is also wrong. Many women were voting before that. So some Western states granted women full suffrage in the late 19th century, basically as a way of recognizing women's contributions to frontier communities. Other states enabled women to vote in local elections, and women used these votes to push for national reform before 1920. So for example, when Illinois granted women municipal suffrage in 1913, Ida B. Wells founded the Alpha Suffrage Club to organize Black women to use these local votes as a way to put pressure on politicians, demanding that they speak for racial justice and against lynching. So they wanted to use this local power to create national reform. Now, Ida B. Wells very much wanted the 19th Amendment to be ratified. She marched in the great national suffrage parade that took place in Washington, D.C. in 1913, in fact, pushing to integrate that parade racially. She campaigned for the federal amendment. She cared very much about that. But she knew that the amendment wasn't going to be enough. So after all, the 15th Amendment, which was passed in 1870, hadn't guaranteed Black men's voting rights or brought about racial justice. Wells wanted equality, dignity, and protection for Black communities, and really for all Americans. When the 19th Amendment passed in 1920, she went right on organizing, still pushing for the federal government to take action against lynching and to try to get Congress to end racialized disenfranchisement in the South. So the 19th Amendment was important for her, but it was not a victory or an end point. It was just one step in a long campaign. And Sarah, I want to turn the floor over to you to hear how you think women's citizenship changed when the 19th Amendment was ratified in 1920.
Thanks, Corey. And I just want to echo your thanks to Susan. Thank you. I've learned so much working with you in preparation for this event. And of course, thank you to everybody in the audience. So Corey, your question, how did women's citizenship change with the passage of the 19th Amendment? It is worth taking a look at what the amendment actually says. And from what I understand, the text of that should be up in the chat box right now. But what the amendment says is, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. And part 2 says, Congress shall have the power to enforce this article by appropriate legislation. Okay, all this amendment says is that you can't use sex to disfranchise people. You can use anything else. It does not establish an affirmative right to the franchise. There is no affirmative right to vote in the United States. And I think this is just worth pausing and reflecting on, particularly now as an election is actually underway and states pass and courts continue to uphold forms of disfranchisement with voter ID laws and such. But even on the terms of the 19th Amendment itself, the amendment failed to confer suffrage to millions of women. Poll taxes, literacy tests, white primaries, and of course, the ever-present threat of violence, to which Ida B. Wells foremost was no stranger, kept many African American women and men from vindicating their right to vote. So the 19th Amendment left a lot of business unfinished, and that business would remain unfinished until 1965, when the Voting Rights Act was passed. So it was only then, in 1965, a century after the 15th Amendment was passed, guaranteeing Black men the right to vote, and nearly 50 years after the 19th Amendment's ratification, that promise of universal adult suffrage in the United States was fulfilled. But even for the white women who were some of the most ardent proponents of the suffrage amendment, voting itself, as you mentioned, was never conceived of as the most important or even the primary expression of what it meant to be a fully rendered citizen or a full-blown member of the US democratic experiment. So for the next couple of minutes, I'm gonna talk a little bit about what happened to feminist organizing after the ratification of the 19th Amendment. So to some extent, the quest for suffrage and the condition common to all women of their exclusion from this very obvious marker of inclusion and citizenship, that common exclusion had papered over differences in women's circumstances. As all women, white or Black, rich or poor, native born or naturalized, working class or elite, all women were excluded from the franchise. Now, some suffrage activists had been animated in their quest to vote by the view that women, as a more virtuous sex, would purify politics, that they would express their uniquely female essence in the kind of policies they voted for. Now, some suffrage activists have been motivated by quite the opposite understanding of women. They thought that women and men were morally identical and that their equality should be recognized before the law. Both camps, equality-minded suffragists and difference-minded suffragists, were still after the same goal before the ratification of the 19th Amendment. But after the amendment was passed, these distinctions were cast into sharp relief. So before the 19th Amendment was even passed, some feminists began to imagine more thoroughgoing alterations to the Constitution to recognize equality of the sexes. A group of feminists led by a lawyer named Crystal Eastman wrote a letter to President Woodrow Wilson as early as 1914, urging him to introduce an amendment that no civil or political right should be denied to any person on account of sex. And this, I think, is really the genesis of what becomes known as the Equal Rights Amendment. And Eastman would continue her advocacy after the 19th Amendment was passed. In an essay she wrote shortly after the amendment's ratification, she framed the achievement of suffrage as just a small piece of a much bigger movement for systemic reform. She wrote, "Now women can say what they are really after. And what they are after, in common with the rest of the struggling world, is freedom. But freedom," she observed, "is a big word." And in articulating her vision of what that big word meant, Eastman invited opposing views. So Eastman worked alongside National Women's Party leader Alice Paul, who had been important in the lead up to ratification, to introduce the first Equal Rights Amendment to Congress all the way back in 1923. And the Equal Rights Amendment would be introduced in every single session of Congress for the next 50 years before any real movement happened. And on that note, I should just say, soon we'll have another centennial to observe, which is the first introduction of the Equal Rights Amendment. Now, the original Equal Rights Amendment read as follows: "Men and women shall have equal rights throughout the United States and every place subject to its jurisdiction, and Congress shall have the power to enforce this article by appropriate legislation." Again, a very short amendment, but one that caused a lot of division, sometimes bitter division. There were many feminist opponents of the Equal Rights Amendment, and these opponents were worried that formal legal equality, the removal of any sex-specific language in law, would hurt especially working class women. So social welfare feminists, in the early 20th century had fought and won victories that resulted in what were known as protective legislation for women. For example, there were many laws on the books, this is industrializing America, that prescribed maximum hours for women workers because women were understood as the weaker sex and that they couldn't be subject to the ravages of factory employment in the same way that men could. And this was also an era where many unions were not interested in organizing women workers. So this protective legislation was cherished by many women, and I should say many men too, as one of the only tools they had to combat the power that businesses had in setting the terms of their employment. And the courts essentially agreed with this view, carving out a space for protective legislation. One woman labor activist decried the Equal Rights Amendment as basically callous and classist. She said that before working hours were legally limited through protective legislation, we were free and equal to work long hours for starvation wages, and we were free and equal to leave the job and starve. On the other hand, for educated women, for the slim proportion of women who went to college, but who also comprised a disproportionate share of the National Women's Party, protective legislation was rooted in harmful gender stereotypes that women were the weaker sex. And these stereotypes actually were bad for women, even if these laws purported to help them. And their vision of freedom was, that big word again, was rooted at odds with the perspectives of working women. So the supporters of the original ERA presupposed a view of the self, the individual, in which all individuals, man or women, were joined in a market society through the bonds of contract and essentially market competition. And for educated middle class or upper class women, women were frequently equal to or more competent than their brothers and fathers, and they were hampered because of their sex from competing fairly in the economic and employment marketplace if jobs were open or closed, or higher education opportunities were open or closed based on gender. So the differences in the kinds of women that advocated for and against the ERA were reflected in their constituencies of support for the original Equal Rights Amendment. The original Equal Rights Amendment was favored at first by conservative women's groups, organizations like the National Association of Women Lawyers, the National Federation of Women and Business Clubs, and the Republican Party placed it on its platform before the Democratic Party. The Republican Party placed it on its platform in 1940, and the Democratic Party would eventually do so in 1944, but it was only over the strenuous objection of labor unions. So with those points in mind, Corey, I want to turn it back over to you and ask you to talk a little bit more about some of the important divisions in the 19th century that you see. I've gone on about class-based divisions in the ERA, but I'm wondering what you see in the 19th century.
Thank you, Sarah. So class is also really important in the 19th century, of course, and there were women organizing in trade unions and striking in the 19th century, some of whom managed to join the suffrage movement and form coalitions. And then one of the things that happens in the early 20th century that actually leads to the passage of the 19th Amendment is large numbers of laboring women do join the organized movement, and women suffragists actually arguably borrow many of the strategies you might think of, like mass parades, from working class women who are developing those strategies before. So, and also a number of socialists are supporting the 19th Amendment as well. So class is always important. I also want to talk in the 19th century about the salience of race, ethnicity, and region as not just divisions, but as lived experiences that really framed how people understood citizenship and the vote itself. And I think this is one of the most recent things to come out of research that's been published in about the last decade, is how women had very different conceptions of what citizenship and voting actually meant. So take, for example, research that Sarah Haley has done on Black women suffragists and their effort to address mass incarceration in the South. So the use of chain gangs, prisons, and jails as a gendered form of racialized violence that targeted Black women as well as men. So Black women in the suffrage movement, such as Mary Church Terrell, worked for prison abolition as part of gender and racial equality. And these suffragists linked voting to broad-based claims for social justice and protection from harm. This justice framework for understanding women's suffrage was different than the rights-based framework pursued by white women and eventually embedded in the 19th Amendment itself. So at a recent suffrage symposium sponsored by the Radcliffe Institute for Advanced Study, Haley really clarified these differences. So she talked about how rights-based conceptions of voting always rely on exclusion. Who has the right to vote and who doesn't? Who has the capacity to exercise these rights and who does not? Whereas justice frameworks for voting focus on community well-being, on struggles for freedom, self-determination, and protection from harm. So it's a very different way of understanding the vote. And I find that really interesting. Other scholars have recently addressed women's suffrage from the perspective of Native women, some of whom did join the organized women's suffrage movement, but always with an eye towards defending claims to Native sovereignty. So these activists developed what Native scholars have called a layered citizenship. That is a claim that you could be both a citizen in the United States and a citizen of a Native nation. Now, in the early 20th century, the US government was very busy pursuing a policy of assimilation that broke up tribal lands, classified most Native peoples as wards of the government who could not vote, and forced those who could vote to renounce their claims to Native citizenship. Now, Kathleen Cahill has tracked how Native women joined the suffrage movement as a way to raise awareness about Native people's needs, both for tribal sovereignty and for political power in the United States. So many of these women did not want the vote if it meant renouncing tribal sovereignty. They didn't want to choose. The dimensions of citizenship looked very different for these women as they promoted these layered claims to citizenship, insisting that they could have Native sovereignty on the one hand and voting in US elections on the other hand, and even in fact that voting in US elections, voting as a bloc, might be essential to ensuring the wholeness of their tribal nations. Now, citizenship looks different yet again if we center women in nations that were colonized by the United States during the same moment that women were pushing for the 19th Amendment. So Laura Pietro has looked at how women in the Philippines reached out to white women suffragists, not just to claim the right to vote, really not even to claim the right to vote at all, but to defend Philippine independence. So for instance, one activist, Clemencia Lopez, came to the US in 1902 to plead for the release of both of her brothers who had been imprisoned for advocating Philippine independence. As a woman, she was actually seen as much less threatening than her brothers, less as of a threat to the US government. So she traveled throughout the United States and she gave a speech to suffragists in Boston in 1902 that convinced many of them to support anti-imperialism. So Lopez allied with white women suffragists in the United States, but not because she wanted to be a voter in the US. Indeed, she did not want US citizenship at all. What she wanted was Philippine independence. So I think that we can see these divisions not only in terms of strategy, but in terms of how people conceived of citizenship. Now, Sarah, I want to turn the floor back over to you.
Based on what Corey was saying, I think she was probably going to ask me, given the concerns of her last remarks, about how women of color in the 20th century conceived of citizenship. And so kind of picking up where the many threads that Corey left us with, I want to just observe that whether or not women supported or opposed the Equal Rights Amendment, feminists have always linked economic and political rights in service of a broader understanding of citizenship that should not just be thought of as formal political rights. And so from the 1920s, for the rest of the 20th century, and I'd argue into the 21st, feminists, and especially feminists of color, would elaborate a range of activities not contemplated by the original authors of the Equal Rights Amendment, but actually harken back to that original women's suffrage abolition movement of the 1930s that Corey alluded to in her earliest remarks. They imagined access to healthcare, an end to sexual exploitation and domestic violence, an end to harassment. They imagined welfare rights, living wages, and reproductive control as a way of asserting what it meant to have a full, equal, and dignified place in the United States. And so it's not surprising that this more expansive vision of sexual and economic justice was most forcefully articulated by Black women in the 20th century whose understandings of what it meant to be equal went beyond the ballot box. And that's, obviously very much in keeping with what Corey has just observed. So the equal rights tradition of the 1920s had implicitly favored wealthy, educated white women who saw themselves first and foremost as women with a capital W, glossing over their racial, sexual, class, educational distinctions. And this equal rights tradition was importantly and decisively remade by feminist lawyers in the 1960s and 1970s. And the key figure here I'd like to talk about is an activist named Polly Murray. She was a key figure, maybe the most important figure in remaking the terms of women's citizenship in the second half of the 20th century. Now, Murray is a tremendously influential civil rights lawyer, but even that kind of morally weighty phrase, civil rights lawyer, hardly does her justice. In her own autobiography, she describes herself as a Black activist, a feminist, lawyer, priest, and poet. And I think that only does her a little bit of justice. But her advocacy stemmed from a specific reading of the history of the women's suffrage movement as riven with factionalization that ultimately pitted Black men against white women, and therefore marginalized the advocacy and influence of Black women, who, as Corey and especially Martha Jones have so aptly shown, was crucial in rethinking what it meant to be a member of the US polity. So as the legal historian Serena Mayeri has explained, in the quest for the 19th Amendment, Murray saw an inspiring but ultimately a cautionary tale, and one that resonated with her own experience of the world. So Murray had struggled with what she called Jane Crow since her days as a law student at Howard University School of Law in DC. Now, her all-male classmates, and in fact, many of her professors too, shunned her, despite the fact that she graduated at the top of her class, was the best student in the class. And when she applied for a fellowship at Harvard, despite the fact that the fellowship at Harvard had traditionally been reserved for men who graduated at the top of the class from Howard, she was rejected. And she was told by the university that members of your sex are not admitted to Harvard University. Now, I should note here, Murray did appeal twice to Harvard. She wrote, "Very recent medical examination reveals me to be a functionally normal woman with perhaps a male slant on things, which may account for my insistence upon getting into Harvard." She was rejected. She appealed again. She wrote, "Gentlemen, I would gladly change my sex to meet your requirements, but since the way to change has not yet been revealed to me, I have no recourse but to appeal to you to change your minds on the subject. Are you to tell me that one is not as difficult as the other?" And those comments are especially interesting in light of the fact that Murray was queer and frequently dressed as a male and passed for a man. Now, in Harvard Law's rejection, Murray heard echoes of yet an earlier rejection she had received from the University of North Carolina when she applied for a PhD in sociology. She was told that she was not permitted to enter the program on account of her race. So on account of race and on account of sex were the twin prejudices, Jane and Jim Crow, that she resolved to fight using the law. And in 1962, Murray wrote a path-breaking memo, which is really a canonical document in the history of constitutional thought. In her memo, Murray was very attentive to the fact that no single kind of woman could speak to the entirety of womanhood. No woman spoke for all women with a capital W. So noting that opponents of the Equal Rights Amendment worried that formal legal equality would undo that protective legislation I talked about earlier, and that some pro-ERA women had seen racial and women's movements as actually antagonistic to each other, Murray proposed that women organize what she called an NAACP for women. and through that organization pursue their own equal rights litigation under the 14th Amendment's Equal Protection Clause. And this was really the founding idea of what becomes known as the National Organization of Women, the famous organization now. And Murray proposed that feminist lawyers would succeed when they actively sought to bridge the gap between movements for racial justice and movements for sex equality. And this intersectional advocacy, this advocacy that recognized that a person's overlapping race, sex, class, disability, immigration status, shapes their understanding and experience of the world, this intersectional advocacy was at the heart of the most important discrimination cases of the 1970s that were most famously argued by Ruth Bader Ginsburg. So Ginsburg learned much from Murray. She had studied Murray's writing and her thought, especially as she was writing a brief for an important case in 1971 called Reed versus Reed. And in her brief, Ginsburg cited Murray's 1965 article called Jane Crow and the Law. And she even listed Murray as an honorary co-author of the brief. So inspired was she by Murray's thought. And in Reed, the case Reed, and in the others she would argue before the Supreme Court in the 1970s, Ginsburg won a new meaning for sex discrimination. And she did so using the theory laid out by Murray several years earlier, based on Murray's fractious reading of the fractious history of the suffrage and civil rights movements. Murray and Ginsburg basically thought that the 14th Amendment's Equal Protection Clause could guarantee gender equality, transforming the 14th Amendment from a guarantor of racial equality to a guarantor of both racial and gender equality. Now, this sounds like an achievement, and it surely is, but it's worth keeping in mind that it took nearly 100 years for feminists to wrest this new meaning out of the Equal Protection Clause of the 14th Amendment. So with that, I want to ask Corey something. So Murray and Ginsburg remade the meaning of the 14th Amendment. And by doing that, they really proved that the meaning of constitutional amendments could change and even expand over time. And so I'm wondering if you see untapped potential in the 19th Amendment itself.
I do, and I also see untapped potential for broadband internet. So with amazingly bad luck, I did just blink out. And if that happens again, Sarah, the floor will be yours for a while until it comes back on. But the 19th Amendment itself, yes, I do think there's untapped potential in it. And it is still there in the chat. And I think part of the untapped potential is that second clause, the enforcement clause, this idea that Congress shall have the power to enforce by appropriate legislation the provisions of this article. Now that is the basically exact same language that is also in the 15th Amendment. And what I want to remind you is that in this year of the centennial of the 19th Amendment, we are also celebrating the 150th anniversary of the 15th Amendment, which said that you can't use race or previous condition of servitude to disenfranchise people. Now, there was a brief moment in the 1870s where the federal government guaranteed Black men's ability to vote in the South. So we had this experiment in interracial democracy that was quite short-lived and tragically ended. And even while it endured, it was as much a paramilitary conflict of intense violence in the South, but with federal troops protecting Black people's right to vote, along with entire Black communities who showed up at the polls on election day, women and children, as well as adult men who could vote. So the federal government can and did once enforce the 15th Amendment. Now, since Sarah told you that, the Voting Rights Act in 1965 really became the key to actual voting rights for people of color, not just Black people, but Latinx people as well in the US. Well, in 2013, the Supreme Court, as you may know, gutted what was left of the Voting Rights Act in the decision Shelby versus Holder. States responded almost immediately with new laws that were meant to suppress voting, things like voter ID laws, removing polling places, making it harder for people to vote. This is the world we now live in, the world that we're voting in right now. Now, these laws have certainly had a disproportionate impact on voters of color, and you've probably heard a lot about that. But these laws also burden women in very specific ways, and actually also trans people and gender nonconforming people. So for example, voter ID laws place more of a burden on women who tend to change their names when they marry. They also place a tremendous burden on trans people and gender nonconforming people who struggle to get adequate IDs to begin with. So eliminating polling places and creating long lines also frustrate women who in practice are much more likely to have childcare and elder care responsibilities than men. So these long lines frustrate women who are trying to vote. Now, this means that voter suppression right now has gendered impacts as well as racialized impacts. So what if we imagined a world in which Congress actually enforced both the 15th Amendment and the 19th Amendment? What might that world look like? Could we have that again? As Sarah said, we don't in the US have an affirmative right to vote, but we do have a constitutional guarantee that our rights will not be taken away on the basis of race or gender. Congress could pass new laws that would ensure that actually happened. And of course, the Supreme Court could interpret those amendments in ways different than they have. So I think that's probably the most obvious untapped part of the 19th Amendment, but there might be another untapped potential in the 19th Amendment as well. So Sarah, as you point out, most of sex discrimination law has developed under the Equal Protection Clause of the 14th Amendment. But the legal historian Reva Siegel has actually made this really interesting argument that there is a way to read, an untapped, underutilized way to read the 19th Amendment in relation to the 14th Amendment in ways that would expand equal protection to encompass discrimination against women within the family. So better addressing issues such as domestic violence that right now really have very little protections for women. So Siegel points out that the opposition to enfranchising women, the reason that it took almost a century, really focused on ideas about the family, particularly the idea that male heads of households should represent their wives and children in politics and govern them in the home. So through the 1910s, opponents of women's suffrage argued that allowing women to vote would destroy marital unity, leading husbands and wives to fight, divorce, and then basically the end of the world as we know it. So really preserving family unity was essential to the notion that women should not vote. And what Reva Siegel argues is that when women suffragists succeeded in actually convincing Americans that they should recognize women as voters, that they should acknowledge them as having what women's suffragists called self-sovereignty, that they were not only giving women the right to vote, but actually reconfiguring the family and marriage to be more egalitarian, to acknowledge women's rights and need for protection as individuals separate from their husbands. So when legislatures finally ratified the amendment after much debate, they knew that they were reconfiguring women's relationship within families and also asserting the federal government's power to intervene in family law, which had usually been seen as a matter for the states to govern. But the 19th Amendment intervened in family law at the federal level. So Siegel argues that actually judges right after the amendment did recognize this reconfiguration of the family, but then they very soon shut it down. So federal and Supreme Courts began to construe the 19th Amendment as only about voting, not about women's subordination in the family. And I think her argument is interesting, though it hasn't been taken up by the courts, in that it points to ways in which the 19th Amendment could be reclaimed as being about more than just voting, but really being about these conceptions of women's citizenship that Sarah and I have been talking about, that go beyond just the right to vote and really look at women's relationship to the government and to the polity and to the family. But this hasn't happened. Sarah, it's arguable that we really do still need an Equal Rights Amendment, as Crystal Eastman recognized even before the 19th Amendment was ratified. So can you talk a bit more about the fate of the ERA after 1970 and even right now?
Yeah, sure. So as many of you probably know, in January, Virginia became the 38th state to ratify the ERA. And the number 38 is crucial here. Mini civics lesson, it represented the final state required to meet the constitutional thresholds, required to amend the Constitution. And it's number 38 because Nevada and Illinois ratified the ERA in 2017. Now, what this means in practice is extremely unclear. Can basically a dormant amendment come back to life like a zombie? Can a state ratify the ERA so long after the deadline set by Congress for ratification has passed? Can states rescind their ratifications, as numerous states have: Idaho, Kentucky, Nebraska, Tennessee, and South Dakota? But the modern history of the ERA is also closely connected with the 14th Amendment strategy pursued by Ginsburg in the 1970s. As Ginsburg was making new meaning out of the 14th Amendment, the Equal Rights Amendment had finally, at long last, passed both chambers of Congress. It passed the Senate in 1972 with a resounding 84-8 votes in favor. And then it went to the states. It took Hawaii all of 20 minutes to ratify the Equal Rights Amendment, and 5 more states did so within 72 hours. By the end of 1973, 24 states had ratified, and it really seemed like momentum was on the side of the ERA. Both parties had it in their platform. Richard Nixon was a supporter. Gerald Ford would be a supporter. And of course, by this time, the Democratic Party stood behind the amendment. Now, we know now that that momentum would stall and indeed reverse itself. And the forces opposing the ERA in the 1970s basically fell into 2 broad camps. The first camp is more familiar. Maybe some of you recognize the name of Phyllis Schlafly, who basically argued that women were better off without an Equal Rights Amendment because women held a superior status in the family because of their role as mothers and housewives. And she also argued, this is during the Vietnam era, that the ERA would make women eligible for a draft. And Schlafly rightly gets a lot of attention for her opposition to the ERA. But behind the scenes, Schlafly was joined by an army of big business lobbyists, most especially from the insurance industry, which had recognized that there was a lot of money to be made in sex differential risk rating. So there's big business and there's kind of a culture war that come onto the scene opposing the ERA in the middle of the 1970s. So in 1982, the ratification period set by Congress, not set by the amendment, but set by Congress, elapses with only 35 states having ratified the amendment. But in 1973, the Supreme Court is considering an important case about sex discrimination in the distribution of military benefits. Again, it's being argued by Ginsburg. And when Ginsburg is making her arguments under a 14th Amendment theory, it seems like momentum is on the side of ERA forces. And what the court decides to do in this case is extremely cognizant of the fact that momentum is on the side of the ERA. The court strikes down the sex discrepancy in benefits, but it declined to subject sex discrimination to the so-called strict scrutiny that race discrimination is subject to. And in part, that's because the justices did not want to preempt the constitutional ratification process that was winding its way through the states. So today, we have neither an Equal Rights Amendment nor an approach to sex discrimination that treats sex as much of a protected category as it treats race. Today, equality for women is subject to law that can be repealed or amended, or it's subject to judicial decisions that don't have to adhere to the highest levels of scrutiny for discrimination. And I think it's worth keeping in mind that courts might also be becoming more hostile to discrimination claims. For example, Justice Antonin Scalia wrote famously or infamously in 2011 that in fact there is no constitutional basis for sex discrimination. So basically a repudiation of the Murray-Ginsburg theory of the 1970s. And his words reflect a view of so-called constitutional originalism, the view that the meaning of the Constitution is what the authors of the Constitution thought as they were writing it. This view was once fringe, but has now become much more mainstream amongst conservative judges. And it is, in fact, the view of Scalia's one-time clerk and now Supreme Court nominee, Amy Coney Barrett. So I'd argue that the need for an Equal Rights Amendment is now more urgent than ever. And in closing, I'd say it's worth reflecting on the fact that momentum for an ERA was reignited in the 1970s. And it was reignited as people around the country were doing exactly what we are doing here, though not on Zoom, they got to be in person. But people in 1970 were reflecting on the significance of the suffrage movement, which was then celebrating or observing 50 years after the ratification of the 19th Amendment. And in the 1970s, ERA supporters drew upon this history of the 19th Amendment, the history with its warts, its factionalism, its racism, but also its lesser known voices that were derided sometimes, but were ideas that were ahead of their time. And feminists of the 1970s drew upon history to advance a new meaning of the Constitution. And I think that the continued advocacy and energy around the ERA is a statement, really, that the Constitution belongs to all of us. And that, to me, is a very powerful legacy of the 19th Amendment. So I'm just going to leave my comments there, and I guess we'll open it to questions for the remaining time.
Okay, great. Thank you so much. This was really great. So as Sarah and Corey have seen the questions, and as we noted, they were sort of broken into questions about the 19th Amendment and questions about the ERA. So first, around the 19th Amendment, Fran Vasily, I hope I'm saying that name correctly, spoke about asking about the percentage of females in the US that were actively involved in promoting the 19th Amendment. So basically, how large was this movement of women?
Friend, it's a great question, and historians would love to know, but we don't really have a way to know that because public opinion polls weren't really developed yet, right? So the best that we can get at is, looking at the women that took to the streets, the women that organized, the women that mobilized. And it is clear that in the final push for suffrage in the 19-teens, more women came out in the streets and joined organizations than ever had before. And it was a remarkably broad coalition. As Sarah said, it really drew in a number of women who had very little in common. In fact, would have fought dreadfully over issues like, social class and who should own property, right? But they all wanted to vote. a lot of women didn't want the vote. So there's also a very large group of organized women who are anti-suffragists, who are saying, you know, Congressman, please don't give us the vote. We don't want to be burdened by this. And they really fall into two groups. And again, I can't give you numbers, but we know their leaders and we know their strategies. And it was wealthy and prominent women in the Northeast who had a lot of political influence. They were married to men with power. They knew men with power. They knew how to get their way. And they thought that voting would actually undercut the power that they already had. And then women in the South who were really nervous that tampering with voting rights in the Constitution at all might mean that Congress would actually enforce those provisions in the 15th Amendment. And they did not want to see, frankly, Black people voting. So we know that these were the anti-suffragists. Interesting fact that is quite clear is that in the late 19th century, the largest movement by far of organized US women was the women's Christian temperance movement that wanted to stop people from being able to buy alcohol. And it was by far the largest movement in terms of dues paying members. It's often a puzzle, especially for undergraduates, of why would this be the biggest movement? But what we need to understand is that it was a movement not just to ban alcohol, but really to end violence against women. I mean, it performed much of the function that the Me Too movement is performing now in ways that you can only see when you look at the history of it. Other big movements were through churches. So like the Baptist Church has a large group of organized women, right? So I'm not able to answer your question in terms of percentages, but I hope that gives you a little bit of flavor of trends.
Okay, great. So, and maybe this is not an easy question to answer either, but James Sheehan is asking about, so when women were given the right to vote in the 1920s, the 1930s, how many women did? Do we know?
Sarah, do you want to?
I don't know. I don't have a good answer for that in terms of percentages either.
So it's small at first, that we can track. And I don't have it memorized, I'm afraid, but I can tell you that, you know, women vote in lower numbers than men. And many women are prevented from voting. So there's a lot of Black women in the South that are trying desperately to vote and are not able to, right? But women who can vote sometimes don't. And the other thing that is quite clear is that women quite quickly get folded into mainstream parties. And the probably biggest reform that women achieve as a voting bloc is actually prohibition, which is put in the Constitution before the 19th Amendment, because politicians are so afraid what women are going to do with those votes. And then pretty quickly by the 1920s, politicians realize that women aren't voting as a bloc. Women are really divided, and we have yet to really realize the potential for women voting as a bloc until quite recently, where it is becoming clear that women are supporting Democrats in much larger numbers than men, though the majority of white women still seem to be Republican, and we'll have to see if that switches in this election or not.
Okay, great. So this question is, you know, it took so long for the movement to achieve the vote. How can that inform us for today, for our efforts today? And maybe Sarah, you can take that one. I mean, what are the lessons learned?
Well, I think one really interesting thing to think about, and this relates to debates that are going to happen about the ERA and the meaning of Virginia being the 38th state, is should there be a time period set on ratifying an amendment? And this was actually something that suffragists considered and rejected when it came to formulating the 19th Amendment. They had considered putting, requesting that Congress say, you know, the states have so-and-so number of years to ratify the amendment. And they rejected that because they thought that for this type of legislation, which, you know, required so many years to even get to the 19th Amendment, that putting a clock, you know, a stopwatch on that would undo decades of struggle. And, you know, part of me feels, you know, quite upset that that lesson was not learned, you know, when the ERA passed Congress in 1972 that they had a congressionally mandated clock that they then extended, but only, it expired in 1982. So I think one lesson is just the observation that social change takes decades and centuries, right? And that frequently, what you see in the history of suffrage is actually ideas that were prominent in the 1830s and 1840s seem to recede that, for example, the idea that there's a natural alliance between civil rights and justice for African Americans and rights for women, that those ideas which were prominent earlier recede, but then they can come into the fore again. So one key insight of Murray and Ginsburg was to try to mend those historical rifts, drawing upon the historical examples of people like, Frederick Douglass, Frances Ellen Watker Harper, and Lucy Stone, people who had seen the potential of interracial struggle as advancing suffrage.
Yes, and I think Julie Ryman is really getting to that sort of juxta of the marginalized groups sort of competing against one another and talking about, has there ever been a time when there wasn't this competition? And then how can we break down those barriers? And that's a huge question. But what are, again, some lessons learned? You think you spoke a little bit about that, Sarah, knowing who the people are that did that work and highlighting that perhaps is a way to do that.
I think one insight is listen to the voices of the marginalized, right? The suffrage movement looks the worst when it's white women who are pitting their own demands for suffrage against the achievement of suffrage for African American men, right? That's the strategy deliberately pursued by Elizabeth, Katie Stanton and Susan B. Anthony. So if you were to listen to the voices of the most marginalized, to women of color who, as Corey mentioned, it's an argument put forth, beautifully in a recent book by Martha Jones, that African American women have been on the vanguard of movements for justice in the United States, and we'd do well to listen to their voices historically, which would also mean we would do well to reconsider the story we tell about the 19th Amendment generally, to consider it in relation, as the legal scholar Reva Siegel has suggested, in conjunction with the Reconstruction Amendments, and not to view it as an achievement in its own right.
I also think that there are great moments of coalition building that you see in both the 19th and the 20th century. But so, when I talked about the origins of the movement for women's political equality in the radical abolitionist movement, that is an incredible moment of interracial cross-class organizing that truly imagines a more perfect democracy that would provide a much truer, broader sense of equality that didn't pit people against each other. During Reconstruction, the American Equal Rights Association wanted universal suffrage for all adults, and actually even Elizabeth Cady Stanton, at her most racist and elitist, Stanton is not just racist, she thinks she's better than almost anybody else in the world, and she is a very brilliant woman who could outthink and outtalk most people. But even at her most elitist, her most racist, she always said she wanted voting rights for all adults. Right? She was always actually committed to universal suffrage. So, and, people like Frederick Douglass and Mary Church Terrell, Black leaders, continued to work with Stanton because they recognized, and I'm not apologizing about her for a second, but they recognized that commitment, that she also, they could form coalitions with her. So I think we do see moments of coalition building that are important to recognize.
Well, unbelievably, we are up to our time right now. So thank you so much. I really appreciate your time, Sarah and Corey. Thank you so much for being here and sharing your expertise and your time. I really, really appreciate it. We started talking about this event back in October, or not in February. So
it was a different time.
It was a
Yes.
different time. So thank you so much for hanging in there
Thank you.
with us this evening. I really absolutely appreciate it.
Thank you.
So thank you. So Lifetime Learning has two programs next week that I just want to bring to your attention. On Tuesday, October 27th at 3 p.m., we have a virtual program entitled The Home Stretch, Election 2020, 1 week out. UVA's Paul Friedman will moderate the discussion with the Miller Center's Bill Anthalis and Mary Kay Carey and the former White House correspondent Ann Compton. And then on Friday, October 30th at 1 p.m., UVA's Kelsey Johnson from the Astronomy Department will lead a program that is entitled, What If We Are Alone in the Universe? Then my next one-day UVA virtual event will be on Friday, November 13th at 1 p.m. for a program entitled A Force for Change, A Century of Women Faculty at UVA. This program will feature a distinguished panel who will celebrate a century of women faculty who broke barriers and diversified classrooms and research labs at the University of Virginia. So I hope you'll join me for that event. So you can keep your eye out for those events and many others at our Lifetime Learning website, which can be found, as you see here, at alumni.virginia.edu/learn. You can register for all of our programs on this site. So in the meantime, please stay safe and be well and enjoy the rest of your evening. And thank you so much for spending some time with us.